As you navigate the executor process, you'll need to determine your priorities as they'll impact the choices you make as you navigate the 100+ steps. Let me propose 5. First, do things right. Quality matters. You're likely going to be tired and grieving as you do this, but you'll want to do a great job for the person you're honoring by serving. 2, work smart. The goal isn't to work hard or to do everything yourself, but to manage the process. If you have great resources or tools that you can use to simplify the process, use them. Third, put family first. I know from firsthand experience how a family can be torn apart in this process, as I watched it happen to both of my parents' families. Make it a goal to make your family relationships stronger during this time frame. Fourth, play fair. You have a legal requirement to put the interests of beneficiaries above your own interests in the process. Doing so will also help you keep your family together during this difficult time. 5, communicate. If you're sincere about achieving these first 4 priorities, make sure that beneficiaries know what you're working on, how you're thinking about their wants and needs, and how you're successfully navigating this process here on executor.org. Executorship can be a tough job, and you'll be managing it during a very difficult time in your life. Don't just plow through it without understanding your priorities. Determine them and then deliver on them. There are meaningful legal obligations that come with the executor role. And for many executors, they're serving for the first time, so everything about the 100+ step process is new. Executor.org can be a great free resource to help educate you on the process, but the best way to manage your legal risk is by hiring a skilled team of professionals to assist you in this process. You'll likely want to engage an estate settlement attorney, a financial planner, and an accountant. You'll need to find and manage all estate assets, including financial assets, personal property, and real estate. The real estate alone can create a great deal of complexity, as you'll need to manage a house without living there, manage ongoing repairs, and take adequate steps to protect it. In the role, in addition to managing, selling, or disposing or distributing of the assets, you'll need to pay relevant creditors. And of course, you'll need to fairly distribute assets, including financial assets and often personal property, in accordance with the will. Finally, failing to successfully execute any of these steps will put you at legal risk. So surrounding yourself with a competent team of professionals who are able to help you manage the process, maximizing inheritances, and managing your legal risk is often an excellent decision. Let's talk now about interviewing the will writer if he or she is alive and of sound mind. Almost no one likes to talk about death. However, if you know or even think you'll be asked to serve as an executor for someone, meeting with them to discuss the estate is an excellent idea. Letting the individual know that you want to have this conversation so that you're better able to act in accordance with his or her wishes when they're gone, and also promote family harmony, can help minimize the initial discomfort of broaching this awkward subject. The conversation will give you a chance to do a few important things that will save you tremendous time and frustration later in this process. In short, you'll be able to confirm that the estate is in order. You'll learn if they've completed a will, where they keep it, and get some sense of whether or not it's been professionally prepared and is legally binding. You'll be able to determine if their will has been amended, and if so, if it's been amended in such a way that that too is legally valid. You'll be able to find important documents like tax returns that you're going to need later. And you're going to be able to make sure that any other wishes of the will writer are adequately reflected in the legal documents, which can provide important clarity later in this process. In the Interview the Will Writer step within executor.org, we'll walk you through a very specific set of topics you'll want to cover in this conversation. Getting properly prepared for the discussion or discussions will be of tremendous advantage to you later in the process when you're no longer able to get your questions answered and will be relying simply on documents to complete this process. Even if you've read the will prior to the death of the will writer, a thorough review of it immediately after their death is an excellent idea. Reviewing the will at this point will help ensure that the deceased's wishes are met as it relates to the funeral. Decisions related to the funeral will need to be made very quickly, and family members will want to know that they're appropriately honoring their loved one by meeting all of their requests. Letting the family members know that you've recently read the will can offer them comfort that they're actually meeting all of these wishes. As you read the will, take the time to understand each term in it so you'll understand the overall document as comprehensively as possible. Our glossary of more than 150 relevant terms here on executor.org can help. Legal documents can be dry and cumbersome, so it may take you a couple of reads of the document to fully grasp its meaning. Invest the time, however, in thoroughly reading and understanding the will, as you'll need to have a strong working knowledge of this document to successfully complete your executor duties. At executor.org, we get emails almost daily from individuals who feel like they picked the wrong estate attorney to guide them through the settlement process. When you're selecting attorneys, as a starting point, it's typically a good idea to find an attorney that focuses on estate settlement versus practicing virtually every kind of law. You want an expert. They'll need to be licensed in the state of residency of the will writer, and if there are properties or assets in several states, finding an attorney or a firm who's licensed in all of those states can make the whole process easier. You'll also want an attorney who's willing to give you the names and numbers of at least 3 clients who they've worked with in the past on this type of work. Talking with those individuals will be very insightful for you. Also, find an attorney who's used to dealing with an estate of the size you'll be settling. If their experiences in dealing with much larger or much smaller estates, it may not be as relevant. Also, understand their fee structure. Will you be charged an hourly rate or a flat fee for settling the estate? Is there a lower cost paralegal who will do some of the work? And what is their anticipated cost for settling the estate, assuming everything goes smoothly? Always trust your gut instincts. If you don't have a good feeling about the attorney, talk to a couple more before making a commitment to one.
Funerals can be very expensive and typically include many types of costs that you'll need to manage but probably hadn't considered. Things like costs to transport the body or funeral home staff and equipment rental for a graveside service. We've created a worksheet on this page to help you budget for and manage the cost of the funeral. Utilize the spreadsheet during the planning process to help you better understand the total cost of the ceremonies and process that you've requested. If you understand all of the various cost components, you're more likely to be more effective in managing the overall cost of the event. You'll likely find this spreadsheet to be an incredibly helpful tool. You can save your information here and access it at any time from this page or also from your data vault, which you can always access from the upper left corner of any page in your plan. Getting the death certificate is another responsibility of the executor. A funeral director will often help in this process, and it's perfectly acceptable for you to ask, but you'll need to provide much of the information needed for the death certificate in order for him or her to help you. The spreadsheet below is a great way to get organized to perform the task. By looking at the required information you'll need, you can gather it ahead of time, enter it in the spreadsheet, and you'll have it available to you when requested by the funeral director. You'll notice that we reference the Social Security number, but do not ask you to enter it into the spreadsheet. We never recommend storing a Social Security number online, even on the most secure of sites. Your next step in the plan will be to think through how many copies of the death certificate you'll need to successfully perform your duties.
There are many notifications you'll need to make when the will writer dies. The first one you should make is the Social Security office. You should let them know as quickly as possible when a person dies. Many people receive benefits that need to stop upon death. If you delay and the benefit is received, it will be the responsibility of the estate to refund that payment. It's much easier to simply stop the payment than create the extra step of having to go back later and refund it. In some cases, the funeral director will offer to help in this notification. If he or she does, you'll need to share the Social Security number of the will writer for them to be able to do so. Some of the deceased family members may be eligible to receive Social Security benefits if the deceased person worked long enough under Social Security to qualify for benefits. For instance, a surviving spouse may be eligible for a one-time payment of $225 if he or she was living with the deceased. There are many potential benefits for spouses, divorced spouses, teenagers, adopted children, so you'll really want to be diligent in your efforts here. If the person was receiving Social Security benefits, you must return the benefit for the month of death and any months after that. If the benefits are received via direct deposit, contact the bank or financial institution and ask them to return any funds that are received for the month of death or after. If you receive the money by check, Do not cash any checks received for the month of the person's death or later. Simply return those checks to the Social Security office as quickly as possible. It's important to know that eligible family members may be eligible for benefits in the month of death of the will writer. So you'll want to contact the Social Security office immediately and understand what your specific situation is. It's absolutely critical to have a competent financial advisor on your team when settling an estate. You'll be dealing with complex and time-sensitive issues, and mistakes cannot be undone and can cost tens of thousands of dollars. If you need help finding all the financial assets in the estate, this is not as easy as it used to be in today's day of paperless statements. You may also need to have some assets valued. You'll need to decide which assets to hold, which to sell, and make sure you're taking advantage of potential tax-saving strategies on retirement accounts in the estate. In hiring a financial advisor, you'll definitely want to understand their philosophies and their experience in helping executors like you who are settling estates. Remember, your goal is to safeguard assets in the estate, not triple them in value, so you'll be looking for a conservative philosophy. Ask them how many years experience they have and what certifications they have as a financial planner, and perhaps about their tax strategies when typically settling an estate. It's also okay to ask for references to make sure they have other clients like you who've been satisfied with their work. And ask yourself, do I trust this individual? If you don't trust them, don't hire them. Most executors figure out in this process that they have work to do in planning their own estate, so liking and trusting an advisor makes them a great candidate to do that work for you as well. Let's talk about your responsibilities related to money and banking. As an executor, it's important that you never commingle your own money with the money of the estate. You must never ever use the estate's money for your personal use, even if you plan to pay that money back. If you do use the money for your personal use, that may be grounds for punishment by the court. So, only an executor with letters of testamentary showing that you have the legal authority to act on behalf of the estate has the ability to close the deceased's bank account. Before you do, however, it's important to check to see if there are any automatic payments that come out of or go into the account. Otherwise, important bills may not get paid. For instance, if the electric bill is paid by autopay and you inadvertently stop that payment during a winter month, this could cause the heat to be cut off, which could cause the pipes to freeze, and suddenly you'll have caused major damage to the home. In some cases, the banks will alert you to these types of auto payments, but sometimes you'll need to review old statements to be sure, which you can request from the bank if you can't find them. Also make sure there are no payments scheduled to come into the account, and also that there are no pending checks that were written but not cleared. If there's an account checkbook, it can certainly be helpful to find it. One final thing to note before closing an account is whether or not it's an interest-bearing account. If it is, and it's a large account, the most responsible thing to do might be to close it the day after an interest payment is made, so the account's at its maximum value. Your time's valuable too, however, so if it's a smaller account or the amount of interest that you'll forfeit is minimal, don't wait to close the account. You've got a lot of work to do, and you'll want to make progress when you can. By the way, if you'd like an attorney to manage this process for you, he or she will be happy to do so, but you'll need to sign a letter of authorization allowing him or her to close or open accounts on your behalf. After you close the account, put the money into a bank account in the estate's name and use that account for all appropriate transactions going forward. In order to open the bank account in the name of the estate, you'll need to obtain a tax identification number for the estate. Consult your attorney, your accountant, or your probate judge if you're managing the process yourself to obtain this identification number. The sale of real estate in an estate will typically be a topic of great interest to most beneficiaries, as in many estates, the real estate is the most valuable asset in the estate. You may also be selling the home that the beneficiaries grew up in, which will of course add to their natural interest in this process. Because of this, it is imperative to communicate with all beneficiaries as you move through this process. Beneficiaries will want to know who you're having sell the home, why you chose that individual, when you're putting the home on the market, at what price, and why. They'll want to understand your plans in terms of the asking price and what you deem to be an acceptable purchase price for the home, and why. If you plan to hire an appraiser, hire someone to declutter the home, or potentially bring someone on to stage the home with furniture if it's empty, you'll want to share your initial thoughts on this with all interested parties and get their thoughts. As the executor, you will make the final decision on these matters, but asking input along the way will help maintain strong family relationships and frankly may yield some great ideas that can help. A beneficiary might also be interested in purchasing the property themselves. If they do, just remember that they'll still need to purchase it at fair market value, just as if you'd be selling it to a stranger. Remember, err on the side of over-communication as it relates to the sale of a home and an estate, and your beneficiaries will be much more appreciative and supportive of your efforts in this process. To calculate the total current value of the estate, you must first complete all of the steps before this one on executor.org. Pay special attention to steps that include finding assets, valuing them, and the payments of debts, taxes, and also the sale of real estate. Please understand that it's possible that there are still debts of the estate that need to be factored into this calculation. If you know a final legal bill, for example, will still need to be paid, you should deduct the amount of that bill as a debt, even though you've not yet received the bill. You cannot make a final determination of the value of the estate until you have a definitive understanding of the final payments that will need to be made to professionals or to anyone else to whom money is owed. Then take the value of the assets, less any bills yet to be paid, and you have the value of the estate. In the executor role, you've recently spent a great deal of time looking at a will and thinking about the estate settlement process. You're probably exhausted at this point and ready for a break. But you likely now also have a better understanding of what you should and shouldn't include in your will and the clarity you can build into it to avoid confusion and frustration amongst beneficiaries later. If you haven't written a will for yourself, now is the time. You might even consider using the attorney you recently used to settle the estate, if you used one, and he or she is in your state of residence. Be sure to incorporate things you found helpful during your service in the executor role. If you already have a will, read it now to see if there's anything you'd like to change now that you've been through the process of serving as an executor. Don't forget to consider things like executor compensation, creating a personal property inventory, and spelling out who might receive specific sentimental items if you believe that they'll hold special value for someone. You should also confirm the validity of an edited will with an estate attorney. Finally, store the will in a safe place. Consider storing a copy with an attorney if someone helped you write it, or giving a copy to a trusted friend or family member. Completing this process now will help give you peace of mind for many years to come. Page is the centerpiece of that plan. On this page, you'll find between 10 and 15 steps you'll need to take, depending on your personal situation and where you are in the process. Within each step, you'll find between 5 and 15 tasks you'll need to complete. If you understand the task, simply check it as complete when you're done with it. If you don't understand it or would like additional perspective, simply click on it to find expert content, helpful videos, or spreadsheets or worksheets where appropriate. When working with your professional team, your plan will help you get organized, stay organized, and create momentum in the process. Another helpful part of the site will be the data vault. You'll find the data vault on the top navigation bar. The data vault will give you direct access to all the relevant worksheets you'll need in this process. You'll find things there like your financial asset spreadsheet, things like your personal property checklist, as well as a place where you can track your relevant expenses, which are reimbursable by the estate. You can also look to the bottom of each page for some helpful resources. There you'll find general articles, blogs, and even a glossary to help you understand important terms you'll need to know in this process. Thank you for putting your trust in us, and good luck on your journey as an executor.